Okay, and that cash component will come back. If you post the cash, either way, you must be at that hearing on November 4th, or the state is allowed to revoke its agreement, and it can argue anything for sentencing. Do you understand that?
Yes, fully.
Very important you make the November 4th hearing, okay?
I fully understand. Yes,
All right.
I will.
Stay in touch with Mr. Feliski, okay? As soon as you're at the treatment facility, make sure you contact him to let him know, and so that you can get an update from him and keep him updated. And so he has a telephone contact for you, etc., and perhaps a person there that you authorize him to be able to speak with, just to see if you're still there and all those things, okay?
Okay.
And your hair is cute. I like it. It used to be long. This is the first time I've seen it short. All right.
The gavel falls. 90 days on paper, but treatment gets priority. Miss Sanite's freedom now hinges on completing rehab or snapping back into jail. It's a rare balance of punishment and second chance. Like, comment, and subscribe for more shocking courtroom stories where justice hangs by a thread.
We will go on the record in the matter 25 CM 86, State of Wisconsin versus Randy Sangate. The state appears through District Attorney Kevin Schmidt in person. We have Joel Feliski, defense counsel, in person. Ms. Sangate appears by video conferencing in custody in Burnett County Jail. We're set today in this matter for a status conference. Mr. Feliski, the court reset this matter at the last hearing last week. Your client was looking at asking the court to have you be withdrawn from the case, and then she stated otherwise, and she wants you still on the case. And she also hadn't yet heard an offer, and you were going to discuss that with her. Mr. Feliski, can you please update the court?
Thank you, Your Honor. I've discussed the offer with Ms. Sangate, and I believe the parties have now come to an agreement. Ms. Sangate has agreed to plead to the count in the complaint, with the repeater dropped, and a joint recommendation by the parties for 90 days jail.
Does she have jail credit?
Yes, Your Honor. I believe she would have 14 days. There was a period, I believe, from 5/7/25 to 5/8/25 where she was in custody, and then she has been in custody since September 4th at the jail here.
And then she understands that if the court does follow that recommendation, that going to treatment will be prolonged?
I believe so, Your Honor. I did speak with her about when this would be scheduled, and she is asking to schedule a separate plea and sentencing hearing.
Why?
That was her stated preference, Your Honor.
The issue that the court has is you have an agreement and you've reached the agreement. The issue is, bluntly, Ms. Sangate has a really poor appearance, court appearance. She fails to appear quite often in her court cases, at least in this county. So, Ms. Sangate, you understand the agreement that's been reached?
I do.
And you're accepting that agreement, and you are going to plead guilty to the charge without the enhancer, and you understand that there would be a recommendation to the court of 90 days jail?
Yes.
And you wanted to tell me something, so what would you like me to know?
Well, back on May 23rd, I was able to make my court appearance out in St. Croix County. So I wanted to...
Again, but I'm telling you, to me, you appearing by Zoom, I didn't even give you permission to do so for that hearing by Zoom when you're in custody in another county. That is for the court to decide, but you appeared, and so the court went on with that. Again, now with this whole Zoom, everybody feels entitled to be able to appear wherever they want. Then there's no accountability. You don't, because if I can appear from Zoom from this jail, or if I go and do something else and I'm in another jail, I'll just appear by Zoom and I'll handle the case and I'll keep it moving on. I have a different philosophy. I believe that if there are allegations of a crime and there's probable cause that the crime did occur, especially that it could be working towards an agreement, there has to be some type of accountability. And I understand that what you were going to say is, well, I could have appeared by St. Croix County Jail to keep the matter moving. You don't get to do that all the time. So, other than that, what else would you like the court to know or to consider?
I would at least like to receive, they said that they don't have Huber or EHM available here and that I would be getting, good time on 90 days.
Yes.
Which is, I believe, a third,
It's a quarter.
a quarter. Okay, so I didn't exactly feel comfortable with the amount. I didn't know, if it was.
Well, I don't
right.
want you to, no, don't talk about that in the ins and the outs of all of that, but just so you're aware, so you can consider and think, 90 days with good time would be 68 days. It would work it down to 68 days. If you have good time, if you're good in the jail and you do all the things and you just abide by the rules, etc. So it would knock it down to 68 days. I'm willing to hear from you and or your attorney as to why the court should consider to amend bond to have you go to treatment, and how you're going to assure the court that this matter will be resolved and we will move forward. What the court could do is the court could take a plea today, stay sentencing, if she is serious about accepting the plea or the agreement with the state. I could stay sentencing and then amend bond and allow her to go to treatment.
Ms. Songate, that what the court has just recited appears to match what we had discussed regarding the specifics of this sentence. So to reiterate, if you were entered the plea today, the court, it sounds like, would be willing to consider staying the sentence and then also amending your bond. That would allow you to go to treatment as you had discussed with probation. Is that something you're comfortable with doing today?
Yes.
Very good.
And so would you like to enter your plea? Do you know that you have the right to be down here with Mr. Feliski in person? Do you understand that, right?
Yes.
And you're appearing by video. Do you wish to enter a plea here today and enter it by video?
Yes.
Okay. If at any time you have any questions or concerns, let me know. I'm going to send Mr. Feliski to Zoom and give you a confidential breakout session, okay?
Okay.
All right. Formal motion to amend count 1 to retail theft without the repeater.
So made.
Granted. Ms. Songate, how old are you?
42.
Can you read, write, and do you understand the English language?
Yes.
Any drugs, alcohol, or other medications in the last 24 hours?
Medications.
Are they medications that would interfere with your ability to comprehend or to understand?
No.
All right. And so other than that, no other medications. Do you suffer from a mental illness or disorder? Like depression or schizophrenia?
Stress syndrome.
What?
Depressive stress syndrome.
Okay, depressive stress syndrome.
Yeah, I've been working on that with psychiatry and psychology for 2 years now.
This twist stings. The defendant admits guilt while also revealing battles with depression and treatment. The judge shows compassion but stays sharp. Is this accountability with empathy or leniency that risks repeat behavior? This tension between punishment and rehabilitation fuels courtroom drama like nothing else.
Well, I'm glad to hear that, Ms. Songate. I really am.
Yes.
Do you understand you would have the right to go to trial? You'd have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You would have the right to testify on your own behalf or remain silent and not have your silence used against you. You would also have the right to have a jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. Do you understand the rights that you would be giving up?
Yes.
You understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
You understand the state would have to prove as to count 1, misdemeanor retail theft, intentionally take, that on or around May 7th, 2025, you intentionally took and carried away merchandise held for resale by Circle K without the consent of the merchant and with intent to permanently deprive the merchant of the full price of that merchandise, and it does not exceed $500. Do you understand what the state would have to prove?
Yes.
You understand that upon conviction, you face a fine of up to $10,000 or imprisonment of up to 9 months or both.
Yes.
You understand that there is an agreement, whereas both sides would recommend to the court 90 days of jail for this count. Do you understand that agreement?
Yes.
You understand that the court does not have to follow that. Let's just say, I think based upon the facts of this case and your history, et cetera, that you should be sentenced to the maximum possible penalty or something in between. Do you understand I could do that?
Yes, I understand.
Do you still wish to proceed and enter a guilty plea?
Yes, I do.
Now, are you admitting here today that you in fact did take merchandise from Circle K with the intent to keep it and not to allow Circle K to have the value of that property?
Yeah. Yes.
Okay, thank you. Mr. Flisky, may the court use the probable cause section of the criminal complaint to find a factual basis?
So stipulated.
Has anyone made any threats or any promises to you, Ms. Songate, for you to plead guilty here today?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes,
and voluntarily?
I do.
Has your attorney represented you competently
Yes.
and he's answered all of your questions?
Somewhat, yeah.
Well, do you have
Yes.
any questions? Do you have any questions he needs to answer before we proceed?
No, I feel good about everything.
All right. And so he's discussed with you potential defenses if the matter were to go to trial or a lack of defenses that you could have.
Yes, he was there for me.
And are you satisfied with his services?
Yes, very.
All right. Then any questions for the court or your attorney before I proceed?
No.
As to count 1, retail theft under $500 without a repeater, how do you wish to plead?
No contest? Or does it have to be
I'll allow-
guilty?
Well, I only accept guilty if you're guilty. I want you to plead guilty. No contest as if there's other things, but I'm not going to fight this one if you want to enter a no contest plea. You said you're guilty of taking the merchandise, correct? And so are you pleading guilty?
Guilty.
All right, guilty. The court will accept your plea of guilt as done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1 without the repeater. A judgment of conviction will be entered today. Let's stay sentencing. Mr. Flisky, can you do Tuesday, November 4th at 1:30?
That will work, Your Honor.
All right. Tuesday, November 4th at 1:30. The court is amending bond and I'm taking away the cash component and making it now a signature bond to allow you to go to treatment, okay?
LLS Affinity Place in Eau
Yes.
Claire, Wisconsin. Yes.
And so you're not going to get out today because part of the bond is going to be, it'll be amended to that signature portion when it's confirmed that you have a bed date and that your agent or a representative from the tribe or someone else can take you to that treatment, okay?
Okay.
And then you must successfully complete that treatment. If you successfully complete the treatment, the cash component will not come back into effect. But if you do not complete that treatment, if you terminate yourself, if you leave that treatment without successfully completing, the cash component will come back and you must report immediately to the jail. Do you understand?
Yes.
Okay, all right. And so here's another deal, Mr. Feliski and Ms. Sangate. I don't know how long her treatment's going to be, how long your treatment's going to be. I don't know if it's going to be over this time, but as you know, the statute only allows me 60 days to be able to push out a sentence. And so if you are still at treatment, okay, if you're still at treatment and you're successfully completing treatment, she may appear by Zoom. All right. And then because I want her to complete treatment, I want her to do these things. And you know that if the court does do a jail sentence, it can be stayed again for up to 60 days. Okay. All right. You understand,
Yes.
Ms. Sangate?
Yes.
Do you have any questions?
No.
Okay, Mr. Feliski, any questions?
Nothing further, thank you.
Any questions?
I know I know the court has pointed this out at other hearings, but I believe it would be especially salient in this one. If she does not appear at all on November 4th, that releases the state from any cap on their argument
All
because
right,
it's a
could you-
deviation of the plea agreement then.
So do you understand what that means, Ms. Sangate?
Yes.
So if you successfully complete treatment and you're still at treatment, you can appear by Zoom. If you don't successfully complete treatment, you're kicked out or you leave, you must return to jail, okay? And that cash component will come back. If you post the cash, either way, you must be at that hearing on November 4th, or the state is allowed to revoke its agreement and it can argue anything for sentencing. Do you understand that?
Yes. Fully.
Very important you make the November 4th hearing, okay?
I fully understand. Yes,
All right.
I will.
Stay in touch with Mr. Feliski, okay? As soon as you're at the treatment facility, make sure you contact him to let him know, and so that you can get an update from him and keep him updated. And so he has a telephone contact for you, etc., and perhaps a person there that you authorize him to be able to speak with just to see if you're still there and all those things, okay?
Okay. Yep.
All right. Anything further?
Not from me.
Nothing further, thank you.
All right, thank you, Ms. Sangate. Good luck, and work really hard, okay?
Yes.
And your hair is cute. I like it. It used to be long. This is the first time I've seen it short. All right, thank you.
This courtroom showdown is heating up fast. State of Wisconsin versus Randy Sanny tape. With repeat failures to appear and a shaky defense, today's hearing tests both patience and accountability. Will justice bend or hold firm? Stick around and subscribe for more dramatic courtroom breakdowns that keep you on the edge.